Hello, everybody. Welcome back. This is Scarlett Pimpernella. I got more good news coming out of Georgia. What you're looking at here is Section 4, Clause 1 of the Constitution. And this is the section that the state of Georgia is in violation of in regards to how the 2020 elections were upheld. A few days ago on the channel, we talked about this lawsuit that happened in March of 2020. And the lawsuit made some changes to how the elections were handled. But what's interesting about this lawsuit is that it was the courts that made those changes through a settlement. And that is clearly in violation of Article 1, Section 4 of the Constitution. It's according to Article 1, Section 4 of the Constitution, it is the legislature that can make changes to how elections are upheld. So I think Sidney Powell has a very good case with the complaint that she filed right before Thanksgiving. There were a number of changes to the in the settlement. Georgia voters had to be notified when officials reject their ballots. What happened, though, more often than not, and we can verify this simply by looking at the Georgia Democrats page here. I'm at the Georgia Democrats voter protection page. And right here on the page, if you click on this link, you can volunteer to be a ballot rescue phone caller, to be in direct contact with Georgia voters. And one of the things that you can help them do is fix absentee ballots. And that was part of what was changed in the settlement. Now, these voters, these volunteers are actually in violation of the settlement because the settlement itself says it's the election officials who have to contact voters. Here we see it says, under the settlement in federal court, Georgia election officials agreed to contact voters whose ballots were rejected. And that is a violation of the Equal Protection Clause. So this, of course, on the Georgia Democrats page indicates that they're contacting only Democrat voters. Furthermore, the fact that you can email these applications, absentee ballot applications, is a security issue because right there on the ballot, it shows who, whether you're a Democrat or Republican. So if multiple people are looking at that ballot, they can see that. Whereas before, the application was at least on paper supposed to be secure and just to go to an election official. So I wanted to check about the complaint just to see if this is Sidney Kraken. I called her Sidney Kraken again, Sidney Powell's train of thought. And if you look at page 18 of the document right here, this is where it starts, Section 40. The United States Constitution sets forth the authority to regulate federal elections. And the same thing, it's the legislature that can regulate elections and not the courts. And so that's what she's saying in this document. Furthermore, she looks at Georgia law, and according to Georgia law, it says when illegal votes have been received or legal votes rejected at the polls sufficient to change or place in doubt the result, that's when you can contest an election. So of course, they're perfectly in keeping with Georgia law in filing this complaint. But this is interesting. In Section 47 of the Georgia, they have a section that talks about the Georgia election code as it relates to absentee ballots. And the courts, when they ruled on the settlement, and Raffensperger and the Democratic Party got together to rewrite how absentee ballots are handled, they're in violation of Georgia election code. So listen to this. It says, upon receipt of each absentee ballot, a registrar or clerk shall write the day and hour of the receipt of the ballot on its envelope. The registrar or clerk shall compare the identifying information on the oath with the information on file in his or her office, shall compare the signature or make on the oath with the signature or mark on the absentee elector's voter card or the most recent update to such absentee elector's voter registration card, an application for absentee ballot or a facsimile of said signature or maker taken from said card or application, and shall, if the information and signature appear to be valid and other identifying information appears to be correct, so certify by signing or initialing his or her name below the voter's oath. So that's in the election code. So when Trump was saying we need to verify the signatures, it's again in violation of the election code that they're not allowing us to even look at the signatures, but because clearly there's a procedure for these absentee ballots. And already with the change to email absentee ballot applications, they're going to have a hard time complying with this. They're just not in compliance with this part of the election code. Look, because in July of this year, Stacey Abrams' Fair Fight Action Committee, Action Organization, she got Secretary of State Raffensperger to change the way that all the counties in Georgia accept email applications. And when she did that, she also changed the way that those email applications were verified, because all you need now is a driver's license, which again is rife for fraud. So let's see, I think I might have covered all of it. Oh yeah, there was one more thing. So this is Doug Ross's infographic on Sidney Powell's complaint. And I just wanted to point out one thing that is a clear indication that something went very wrong with this election. Sidney Powell has compiled the numbers for absentee ballot signature verification rejections. And this is from page 85 of the complaint. We could go there too, but Ross says, Democrat majority counties perform virtually no signature verifications, allowing massive illegal vote dumps for Biden. And this is the part that's really just blows your mind. The signature rejection rate for the most recent election announced by the Secretary of State was 0.15%. The signature rejection rate for absentee ballot applications was 0.00167. There were only 30 statewide. And if you look straight on the Secretary of State's website, they have the numbers for how many absentee ballots were received and submitted this year. There were 1.3 million, approximately 1.3 million ballots received. So, and 1.8 million, almost 1.8 million absentee ballot applications. So and that's a 600% increase from 2016 of the number of absentee ballots. And in 2016, they got about a little bit over 200,000 and rejected about 6.4%. So the Democratic Party, Raffensperger, Abrams, they don't have a leg to stand on. The Constitution is clear. It says the times, places, and manners of holding elections is prescribed by the legislature, not the courts. And in March 2020, as it says in this article by Mark Neese, the courts changed the way that absentee ballots are handled, and they expanded the ways that they could be received. They limited the ways that they could be rejected. And you've got just a huge ballot dumps for Biden. So that's all I've got for today. I hope you have a wonderful day. Thank you so much for tuning in. Bye-bye. you.